The revised rules of civil procedure introduce significant amendments to the rules on pre-trial. Under the revised rules, the following shall be done during the pre-trial hearing: marking of evidence, comparison of original evidence vis-a-vis copies, stipulations regarding the faithfulness of the reproduction and genuineness and due execution of the adverse party's evidence, reservation of testimonial evidence not available at the pre-trial by giving the name or position and the nature of the testimony of the proposed witness, and reservation of documentary and other object evidence by giving a particular description of the evidence. Pre-trial, it is a procedural device intended to clarify and limit the basic issues between the parties. Its main objective is to simplify, abbreviate, and expedite trial or otherwise dispense with it. Under the 1997 rules, it is the duty of the plaintiff to move ex parte that the case be set for pre-trial conference. Now, the new rules remove this requirement. After the last responsive pleading has been served and filed, the branch clerk of court shall issue within 5 calendar days from filing a notice of free trial, which shall be set not later than 60 calendar days from the filing of the last responsive pleading. The 1997 rule simply provides that notice shall be served on the counsel or on the party if he or she has no counsel. The counsel served with such notice is charged with the duty of notifying the party represented by him or her. This is still the same requirement under the 2019 amendments, but with additional directive that the notice of pre-trial shall include the dates for pre-trial, court annex mediation, and judicial dispute resolution if necessary. It shall be the duty of the parties in counsel to appear at the pre-trial, court annex mediation, and judicial dispute resolution. Failure of the plaintiff counsel to appear will be a ground for the dismissal of the action with prejudice, unless otherwise ordered by the court. Failure on the part of the defendant and counsel will allow plaintiff to present evidence ex parte within 10 calendar days from the termination of the pre-trial, and the court to render judgment on the basis of evidence offered. The specific period, 10 days, has been added in the 2019 amendments. Under the 2019 amendments, the court shall also consider the requirement for the parties to mark their respective evidence if not yet marked in the judicial affidavits of the witness, examine and make comparison of the adverse party's evidence, manifest for the record stipulations regarding the faithfulness of the production and genuineness and due execution of the adverse party's evidence, and reserve evidence not available at the pre-trial. The failure without just cause of a party in our counsel to bring evidence shall be deemed a waiver of the presentation of such evidence. The branch clerk of court shall prepare the minutes for the pre-trial. The failure without just cause of a party and counsel to appear during pre-trial, despite notice, shall result in the waiver of any objections to the faithfulness of the reproductions, mark, or their genuineness in due execution. Note that this provision should properly apply only against the defendant. The amendments provides that absence of the plaintiff during pre-trial shall result to the dismissal of the complaint, while the absence of the defendant will result to plaintiff presenting evidence ex parte. As to the filing in service of pre-trial brief, the 1997 rules provide that it must be done 3 days before the date of the pre-trial. To remove any confusion with the weekends should be included in the counting of the period. The 2019 amendments provides that the parties shall file with the court and serve on the adverse party in such manner as shall ensure the receipt thereof at least 3 calendar days before the pre-trial. Please take note of the content of the contents of pre-trial brief. The pre-trial brief must contain, among others, a concise statement of the case and reliefs prayed for, a summary of admitted facts and proposed stipulation of facts, the main factual and legal issues to be resolved, the propriety of referral of factual issues to commissioners, the documents or other object evidence to be marked, stating the purpose thereof, the names of the witness and the summary of the respective testimonies, and a brief statement of points of law, citations of authorities. Some items also have been removed under the 2019 amendments. This includes the statement of the willingness to enter into amicable settlement or alternative modes of dispute resolution, and a manifestation of their having availed of or their intention to avail themselves of discovery procedures. Take note that failure to file pre-trial brief shall have the same effect as failure to appear at the pre-trial conference. The old 1997 rules provides that upon the termination thereof, the court shall issue an order which shall recite in detail the matters taken up in the conference, the action taken thereon, the amendments allowed to the pleadings, and the agreements or admissions made by the parties as to any of the matters considered. Should the actions proceed to trial, the order shall explicitly define and limit the issues to be tried. These items have been significantly expanded under the 2019 amendments with a specific period for the issuance of pre-trial order. The 2019 amendments now requires that upon termination of pre-trial, the court shall issue an order within 10 calendar days, which shall recite in details the matters taken up. The order shall include enumeration of admitted facts, the minutes of pre-trial conference, the legal and factual issues to be resolved, the applicable laws laws, rules, and jurisprudence, the evidence mark, the specific trial dates for continuous trial which shall be within a period provided by the rules, the case flowchart to be determined by the court which shall contain the different stages of the proceedings up to the prolongations of the decisions, and the use of time frames for each stage in setting the trial dates. And a statement that one, the examination of witness rule, most important witness rule, shall strictly be followed. And a statement that the court shall render judgment on the pleadings or summary judgment as the case may be. The direct testimony of the witness for the plaintiff shall be in the forms of judicial affidavits. After the identification of such affidavits, cross-examination shall proceed immediately. Postponement of presentation of the party's witness at the scheduled date is prohibited, except if it's based on acts of God, force majeure, or duly substantiated physical inability of the witness to appear and testify. The party who caused the postponement is warned that the presentation of its evidence must still be terminated within the remaining dates previously agreed upon. Should the opposing party fail to appear without valid cause, the presentation of the scheduled witness will proceed with the absent party being deemed to have waived the right to interpose objections and conduct cross-examinations. The contents of pre-trial order shall control the subsequent proceedings unless modified before the trial to prevent manifest injustice. The 2019 amendments now expressly provides for court annex mediation. After the pre-trial and after issues are joined, the court shall refer the parties for mandatory court annex mediation. The period for court annex mediation shall not exceed 30 calendar days without further extension. Only if the judge of the court to which the case was originally referred is convinced that settlement is still possible, the case may be referred to another court for judicial dispute resolution. The judicial dispute resolution shall be conducted within a non-extendable period of 15 calendar days from notice of failure of the court annex mediations. All proceedings during the court annex mediations in the GDR shall be confidential. If judicial dispute resolution fails, trial before the original court shall proceed on the dates agreed upon. The 2019 amendments inserts an entire section regarding judgment after the pre-trial conference. These additional provisions are very significant. After the trial conference, a party may move for judgment After the pre-trial conference, a party may move for judgment on the pleadings under Rules 34 or summary judgment under Rule 35. These remedies, while not provided in Rule 18 of the old 1997 rules, are already available under the old rules. The more significant addition is this: after the pre-trial, the court may motu proprio include in the pre-trial order that the case be submitted for summary judgment or judgment on the pleadings without need of position papers or memoranda in the following instances: should there be no more controverted facts or no more genuine issue as to any material fact or absence of any issue, or should the answer fail to tender an issue. The order of the court to submit the case for judgment pursuant to this rule shall not be subject to appeal or certiorari. In such cases, judgment shall be rendered within 90 calendar days from the termination of pre-trial. That, ladies and gentlemen, is pre-trial. Good evening.